Commissioners, this is Troy, your host. Looks like we're all ready and set to go.
Troy, thank you so much. We'll call this meeting to order in about a minute here. Commissioner, you all set? Okay, Commissioner. Great. Well, welcome everybody. I'd like to call to order this meeting, public hearing of the Board of County Commissioners, land use meeting and public hearing for Tuesday, May 27th, 2025. If you'll all rise and join me in the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. Attorney Garcia, do we have certification of the agenda today?
You do, sir. The County Attorney's Office has reviewed all items on the agenda. Appropriate posting has been made where necessary, and you otherwise have jurisdiction over these matters.
Great, thank you. And do any commissioners have disclosures for items on this agenda?
No, sir.
No. And I have none either. With that, we'll move on to item 2, our land use meeting agenda items. We actually have no items for land use, but we do have public hearing agenda items under item 3. The first is item 3A, the Range Preliminary Plan Project File SB 2024-048. Mike Pasica from staff presenting. Mike?
Thank you, Chairman Layden. Good afternoon, Commissioners. Mike Pasica, representing Planning Services. And the request before you is the Range Preliminary Plan, project number SB 2024-048. Brian Horan and Troy Bales of Rick Engineering are here this afternoon on behalf of the owner. The Range Preliminary Plan proposes 550 units on 399 acres in Planning Area 1 and Planning Area 2. And 240 acres, or approximately 60% of the site, will be set aside as open space. Central Water and Sewer Service is provided by the Range Metropolitan District through a service agreement with Dominion Water and Sanitation District. The agreement has been executed and was provided to the board prior to today's public hearing. The intent of a preliminary plan process is shown on this slide. The preliminary plan process begins with the submittal of an application. Following comments by staff, the request is forwarded to referral agencies, and courtesy notifications of an application in process are mailed to abutting landowners. The applicant is given an opportunity to address referral comments and other issues before public hearings are scheduled before the Planning Commission and Board of County Commissioners. Major referral comments generally concerned access, drainage, water, and traffic issues. The applicant addressed engineering comments applicable to the preliminary plan. Additional review is required at final plat. CDOT will require construction of new traffic lanes at both the north and south access points proposed for the range development, and dedication of land for a future interchange at Airport Road and Highway 85. The Colorado Division of Water and the county's water consultant reviewed the proposed water plan, which demonstrates adequate water supply to serve the development. The applicant has received approval of its wildfire mitigation plan by the county wildfire mitigation specialist and approval of the weed mitigation plan from the county's weed specialist. Wildlife corridors are shown on the preliminary plan and will be maintained by providing open space areas and clustering residential lots. Proposed fencing will be limited, and if used, it will be wildlife friendly as recommended by the applicant's wildlife preservation plan. South Metro Fire has no objections to the proposed preliminary plan. During the process, staff received comments from the Highlands Ranch Community Association and 2 adjoining property owners. HRCA had comments concerning buffering, possible trespass onto the Highlands Ranch backcountry area, wildlife impacts, and noise, sight, and light pollution. Public comments noted concerns with access, construction activities, wildlife, water resources, noise, and lighting. All referral, HOA, and public comments are attached to the staff report, along with the applicant's responses. The Planning Commission heard the proposal at a public hearing on May 5th, 2025, and unanimously recommended approval by a vote of 7-0. One member of the public commented on the preliminary plan. Susan Poet, the adjacent property owner, expressed concerns with the application, which she noted were being worked out through ongoing discussions with the applicant. She requested that the The Board of County Commissioners consider conditions of approval, including requiring a shared access agreement prior to final plat approval, requiring the range's acquisition of 1.5 acres of their land for the northern access into the subdivision, which is condition number 3, providing an opportunity to be involved in the review of future location and extent applications for the necessary water and sewer infrastructure, and establishing a 1,000-foot setback from their property line be applied to any new wells drilled on the range development. Staff confirmed that these will be brought forward to the board, including additional proposed conditions where appropriate. Run through a few maps. The approximate area of the project site is shown with the red star right there. And it's located on the east side of Highway 85 at Airport Road within the Louviers rural community of the 2040 Comprehensive Master Plan. This is the zoning map. The property is shown in red. It's located on the east side of Highway 85 at Airport Road. There's rural residential zoning to the north, agricultural one to the south, planned development zoning to the east, and A1 and planned development zoning to the west. Again, the property is highlighted in red on this aerial photo. It abuts the Highlands Ranch backcountry to the east, and existing development in the Cherokee Ridge Estate subdivision to the north. RV storage in the Kellytown East PD is to the northwest. The western border includes CDOT right-of-way for Highway 85 and an existing A1 parcel used for agricultural and residential purposes. And to the south is an A1 parcel used for agriculture. The property was zoned residential with the inception of zoning in Douglas County in 1955. In 1982, the majority of the parcel was designated Agricultural 1 or A1, with the northernmost portion designated rural residential. In 2021, the property was rezoned to planned development. The parcel has historically been used for agricultural purposes. Shown here is proposed preliminary plan. North is to the right on this slide, overlaid on the approved range PD zoning exhibit. Planning areas 1 and 2, where the residential areas are proposed, are shown north and south of the Daniels Park drainage, which runs right through the property right there. Open space areas 1, 2, and 3 are shown and provide a buffer for the development to adjacent properties and also act to preserve wildlife habitat and natural features. The Daniels Park drainage and provide room for wildlife movement. A future community activity center is proposed within the center of the site, and it could incorporate the existing barn structure. Access is proposed from 2 points at the north and south to Highway 85. The northern access is proposed to align with Airport Road. The applicant is committing to dedication of land for a future Airport Road and Highway 85 interchange. The residential lots are located in planning areas 1 and 2 of the range plan development. Proposed lot sizes range from 5,625 square feet to 23,854 square feet, with a minimum lot area requirement of 4,000 square feet and a maximum building height of 35 feet per the range PD. All lots are designed to accommodate detached single-family dwellings. And a future community center is proposed in open space area 3. And a network of trails is planned in and around the residential and open space areas. The northern access point into the development will cross a small area of private property right in this area there. The applicant is coordinating with that property owner to identify the limits of the area to be purchased for that access. The size and configuration of the purchase will be finalized at the time of final plat and is intended to be limited to the area required for maintenance of any proposed improvements and disturbed areas requiring revegetation. The planned development requires a 100-foot buffer to the north from Cherokee Ridge Estates, a 100-foot buffer to the south, a 100-foot buffer from Highway 85, a 50-foot buffer from the property to the west, and a 15-foot buffer to the east and north adjacent to the Highlands Ranch backcountry, and the preliminary plan meets these buffering requirements. These next 2 slides show the northern portion of the preliminary plan in greater detail. The light blue highlighted and hatched areas is the Daniel Park drainage and 100-year floodplain, which also serves as an existing wildlife movement corridor. The 2 roads crossing the floodplain will require approval of a CLOMR prior to approval of the final plat. This slide shows the area in and around the northern access point into the preliminary plan. The north access point is where the applicant has committed to dedicating a maximum of 7 acres for a future interchange at Airport Road and Highway 85. The adjacent property is also shown for reference. Prior to approval of the first final plat, The applicant is required to obtain land from the adjacent property owner, right here, for construction of the access that is proposed across their property. The poets have asked that the applicant work with them to define a shared access point along that entrance road. Various supplemental exhibits are submitted with the preliminary plan application. This one shows a portion of the wildlife corridors as they relate to the subdivision layout. Wildlife corridors will be maintained and protected from residential development by locating lots north and south of the Daniel Park drainage. If fencing is used, it will be wildlife friendly per the recommendation of the applicant's wildlife preservation plan. Quickly run through some site photos. This view looks north through the site. You can make out the RV storage lot and homes in Cherokee Ridge Estates at the top of the ridge. This photo looks southwest across the southern edge of the property, and you notice the topography change as preserved in Open Space Area 1. This view looks east through the site towards the Highlands Ranch backcountry in the background. And this view looks at the existing barn structure identified as the future community activity center on the preliminary plan. And this view looks north from the middle of the site through the Daniels Park drainage. The approval standards for a preliminary plan request are set forth in section 403 of the subdivision resolution and listed on this slide. Staff's assessment of the approval standards, including subdivision design, are discussed in detail within pages 10 through 14 of the staff report. Staff has evaluated the preliminary plan in accordance with Article 4 of the Douglas County Subdivision Resolution. Should the board find that the approval standards from the preliminary plan are met, the following proposed conditions should be considered for inclusion in the motion. This first condition, number 1, has been met. The executed agreement has been provided. There are now 13 conditions of approval. Condition 2, prior to approval of the first final plat, the applicant shall file a required well abandonment report with the Colorado Division of Water Resources or obtain a court-approved augmentation plan to allow the wells to continue to be used. Condition number 3, prior to approval of the first final plat, the applicant shall purchase that portion of land from the adjacent landowner, Poet, its successors, and assigns associated with the northern access road into the range subdivision. Oops. Condition number 4, prior to approval of the first final plat, the applicant shall finalize a shared access easement or agreement with the owner of the adjacent property at 7680 North US Highway 85. Condition number 5, prior to approval of the first final plat, location and extent applications shall be approved for water and sewer infrastructure improvements necessary to serve the range. Condition number 6, prior to approval of the first final plat, an open space protection agreement shall be approved by the Board of County Commissioners. Condition number 7, prior to recordation of the first final plat, the applicant shall obtain approval from the Board of County Commissioners to release its declaration of restrictive covenants for water to allow conveyance of the property's Denver Basin groundwater rights to the Dominion Water and Sanitation District. Condition number 8, concurrent with or prior to recordation of the first final plat, a maximum of 7 acres of land shall be dedicated for the Airport Road interchange improvements. Condition number 9, prior to issuance of the first building permit, the owners and their assigns shall pay cash in lieu of land dedication to the Douglas County School District to Douglas County. Condition number 10, prior to issuance of the first residential building permit, the applicant shall implement the subdivision-wide recommendations of the wildfire mitigation plan. Condition number 11, during construction activity within the development, the applicant, its successors, and assigns shall conduct a burrowing owl study if any earth moving will take place between March 15th and October 31st. Condition number 12, during construction activity within the development, the applicant, its successors, and assigns shall take all reasonable care to watch for historic resources, paleontological resources, and other cultural history resources, and shall immediately notify Douglas County and complete appropriate Colorado Office of Archaeology and Historic Preservation data management forms in the event of such discovery. Condition number 13, technical corrections to the record copy of the preliminary plan exhibit shall be made to the satisfaction of Douglas County. Condition number 14, all commitments and promises made by the applicant or the applicant's representative during the public hearing and or agreed to in writing and included in the public record have been relied upon by the Board of County Commissioners in approving the application. Therefore, such approval is conditioned upon the applicant's full satisfaction of all such commitments and promises. Section 40508 of the subdivision resolution sets forth the parameters for the board's recommendation on preliminary plan requests as noted on this slide. And this concludes staff presentation. I'm available to take questions on the staff report at this time if the board wishes. Otherwise, the applicant is here to present. And I do want to note to the board that we do have the county's water consultant available online in case you have questions for him.
Okay, great. Thank you, Mike, for that presentation. Any questions for staff?
No questions.
Yeah, actually, Chair, I do have a question
Yes.
or two, and it may be, and if you want to defer to the later presentation, that would be fine as well. But what is the future of Airport Road and that intersection with Santa Fe? And is there, was trying to read through those 13 conditions. Is one of those conditions an assistance in paying for upgrades to that intersection?
Not one of those conditions. There is a commitment in the PD to make a traffic impact fee per unit. And that's a commitment that would be carried forward when they start applying for building permits.
And is that traffic impact fee per unit based on plans to upgrade that intersection?
I believe so. I might ask our engineering services is here today with us to comment on that, Ken Murphy.
Okay. That would be great just to know that because that intersection is going to go from the current airport road to the current airport road plus 550 new homes, so.
That's right. That impact fee is similar to the one provided by Starling Ranch and does include impacts for the interchange.
Okay.
Great. I do have a couple of questions, but I'll reserve those following the applicant's presentation. If the applicant would like to come up to the podium, state your name and where you're from. I think we know that, but we'll get that on the record.
Okay. Good evening, Commissioners. My name is Rob Fitch with Rick Engineering Company. Our address is 8678 Concord Center Drive in Englewood, Colorado. We're here today to present our application for the preliminary plan for the Range project. With me here today is Troy Bales, the project manager and civil engineer of work. I have Ms. Andrea Cole, General Manager from Dominion Water and Sanitation District. We have Mr. David O'Leary here from Spencer Fane for our Metro District Legal Counsel, and then Mr. Brian Horan from the Ownership Group. What I would like to do today is present some approval criteria and slides from the applicant side. It'll complement Mr. Pasica's detailed presentation and will be available for questions after our presentation. The purpose of our hearing today is seeking approval for the Board of County Commissioners on our preliminary plan. As referenced, we are the 399 acres just east of US 85. We are currently under a planned development zoning, which was approved in December of 2021. A little bit more about the preliminary plan and the highlights. We are proposing 550 single-family residential lots. We are dedicating 240 acres of open space, which provide the buffers that Mr. Pasica outlined around our development. We have 2 access points off of Highway 85 that we'll highlight in a little more detail. And then the entire preliminary plan is in conformance with the planned development. In relationship to the planned development, you can see our 2 planning area bubbles on the left-hand side. Those are our development areas for the PD. And then on the right, you can see the overlay of the darker shades showing that our residential development and lots are within the planned development planning areas and setbacks. As it relates to open space, we are dedicating over 60% of the property to open space, which will be owned and maintained by a metro district and governed by an open space agreement with the county. We are setting aside a 5-acre tract for a community park, which will be utilizing the existing barn as a community amenity. And then highlighted in purple on the site plan to the right, you can see our network of trails, which is currently over 5.5 miles. And we are preserving the wildlife corridors, which I'll highlight on the next slide. In addition to the trail network, we are proposing wayfinding signage and trail signage to educate the pedestrians to the wildlife in the area, the property boundaries to limit trespassing outside of the trails, and the benefits of staying on the trails in an open space environment. As it relates to the wildlife corridors, on the left you can see our wildlife study completed by ERO and consultants during the plan development. There's 3 major wildlife corridors to the north, through the center, through Daniel Park Drainage, and to the south. And then on the right, you can see in the purple arrows the wildlife corridors that are still being preserved with the development. As it relates to water and sewer, it has been no small feat, I think, getting water and sewer to this development. We are in a position now where we are provided wholesale water and sewer service from Dominion Water and Sanitation District. The Range Metro District will be the retail water provider. And in order to get water and sewer services to our site, we are constructing and paying for over 3.5 miles of water and sewer that are going to serve the Range development only. And that's highlighted in the green and light blue infrastructure lines on the screen. In addition to the utilities that we're extending to serve our site, Range is contributing to the US 85 corridor by, 1, paying for the design and construction of the water line servicing both Range and Leviers. So that's the dark blue line that would be coming from Dominion, extending to the region. We are paying for the design and construction of a sewer lift station and force main that'll also service the Range and Leviers development. And then we are also, per the PD, committed to paying for the Leviers tap fees to tie into the Dominion water system, 113 homes. And so there's an approximate value of just over $19 million that the Range project is contributing to the corridor for the water and sewer services. A little bit about the Range Metro District. We are established in 2023. We do have an executed IGA with Dominion Water and Sand District, executed prior to this hearing. And as it relates to operation and maintenance, we're proactively negotiating contracts with qualified management and engineering consultants for the operation and maintenance of the retail water and sewer service. We are working with Aqua Engineering to design the feeder line and the on-site storage facility that's required for fire. And so we will have an operating consultant firm in place for the Range Metro District's portion of the retail water. For traffic, we do have 2 access points approved by CDOT and the county in our traffic study. The northern access is at the existing signal at Airport Road, and the southern access, which would be built with the first phase, is along a medium break in Highway 85, and it'd be a 3/4 movement. Our CDOT's improvements do include signal modifications at Airport Road, and then the associated acceleration and deceleration lanes for our access points. We are committed to dedicating 7 acres of land for the future Airport Road intersection. And then we, as mentioned with your question, Commissioner, pro rata share for the regional traffic projects per lot committed in the plan development. A little more detail on the northern access. This is a requirement for us to access Highway 85 adjacent to Airport Road. We've worked with the county and the poets to minimize disruptions to their property. We do have a design variance for the geometry that you're looking at. And then highlighted in orange is just around 1.5 acres of land that we would ultimately procure from the poets prior to final plat, and we've been in negotiations with them to date on that. Another part of the condition that Mr. Pasica referenced is access to the southern property of the poets parcel. They have 2 portions of the property, a northern portion of north of Daniels Park Drainage in the south. Our PD has an access point going to the north, but in our negotiations with the poets, they are looking for access off of our development road to access the southern portion of their property, and we're happy to facilitate those conversations in an access agreement, or should they know where their road is at time of final plat, an access easement. As it relates to drainage, we've been successful in setting back the development from the major drainage way, certainly to minimize impact and keep the existing natural channel. We've had field meetings with Mile High Flood District and county drainage personnel on site to minimize the impacts. You can see we have a network of regional detention and water quality ponds, eliminating any downstream issues or concerns to neighboring properties. But we've had a really good success with working with Mile High Flood Districts on the drainage design for the Daniels Park drainage. School and park dedications, just to reaffirm our commitment. We do anticipate park dedication being a combination of cash in lieu and land dedication. We're required for 24.75 acres of equivalent park dedication. And then the school dedication will be cash in lieu at time of building permit as outlined in our conditions. A little bit on community outreach. We have had various meetings with our neighboring with our neighbors, inclusive of the Poet family, where we've been able to discuss our access points, the sewer alignment that we will need to go through their property. Drainage impacts have been, minimized, and no downstream issues will occur on their property from our drainage design. And so we've worked with the Poets on multiple occasions from the PD to the preliminary plan point we're at now. Our northern property owner, we have met with the Weavers. We have a 500-foot buffer from the north. And then we are aware of the Highlands Ranch Community Association comments about the need for signage and trail components. We are looking at fencing the residential communities, but not installing any perimeter fencing other than a wayfinding signage. And we're consistent with the buffers as shown on the PD. We have had substantial coordination since the PD, even prior to that, with the Laviers community, Dominion Water and Sanitation District, the Range Metro District, and the Douglas County entities to get to our water and sewer service infrastructure that we're at today. And then we've had very successful coordination with Mile High Flood District and CDOT on this development application. Look ahead schedule. We're going to continue to do subdivision platting through this year. With the hopes of beginning construction next year. First home occupancy anticipated in 2028, with build out 5 to 7 years later. On the screen before you is the approval criteria, which we feel we've met in conjunction with the staff report that was presented today. And in summary, we believe our application complies with the Douglas County subdivision regulations, Articles 403. We conform with the Douglas County 2040 Comprehensive Master Plan. We comply with Section 123 of the Douglas County Zoning Resolution. We are consistent in complying with our approved PD. And the conditions of approval as outlined by Mr. Pasica, we acknowledge and we accept as proposed to this moment. And with that, I would like to take a moment to thank the Board of County Commissioners for your time here today. Certainly Ms. Baer and Mr. Pasica for your help in processing this application. And then certainly to the Poet family, who we've been able to meet with, and they've been very active in this application, and they're here today. So we appreciate their time in coordinating with us to this point. So with that, we're open for questions or any comments.
Great. Well, thank you for that presentation. Board, any questions for the applicant?
Yeah, just a couple of questions. So just want to make clear, I mean, remember when you guys were in here for the initial zoning? And you guys talked about having water service, sort of, but not quite, not agreed upon, but just want to make sure, just as it gets said so it's clear, you guys have completed a water services agreement with the Dominion, I believe?
That is correct.
Okay, that's all signed up and buttoned up, and we saw it removed as a condition for that reason.
That is correct.
Okay. I think that's my question and answered.
Okay, thank you, Commissioner. Commissioner Van Winkle.
Oh, thank you, Mr. Chair. And sir, I do know you referenced the letter from HRCA, which listed essentially 5 points of contention. What communication have you had with HRCA in response to their letter, and has there been solutions found?
Our communication with the Highlands Ranch Community Association letter was essentially in response to comments through the application. As their letter was received, the 5 points were very similar to the comments presented in the plan development application. And so at the time that those comments were addressed and codified in the plan development, we've been consistent with the setbacks from the PD. And we've, I think, as the proposal of the interpretive signage along the trail and trying to minimize any disruptions between that property boundary are in place and can continue to get solidified from now until the final plat process.
Okay. And specifically to, I think the trespassing onto a wildlife corridor, and then the very last point, which is hunting, it says backcountry currently hosts over 30 hunts per year for elk, deer, coyotes, and coyote. The area is very close to the planned development. Was there any conversation with HRCA regarding those hunts per year and those continuing perhaps in the future or perhaps not?
Aside from the fact that they have that right and ability with their open space as an established use, we recognize that. We share their concern with trespassing with the point where we don't want any individuals in the Highlands Ranch open space to be coming onto our property just as like we don't on theirs. And so the proper use of the trail going through open space and the signage and having any residents with proactive materials for wildlife in the area and respectful use of the trail is what we would expect to be done by both parties.
Okay, thank you.
Great. So, just going back to your presentation, obviously there was a series of comments made by the Colorado Division of Water Resources from their letter of 9/30/2024. I think you did a good job of summarizing, staff summarized all those comments, but a lot of that is associated with the will serve letter from Dominion. So I'd ask the representative from Dominion to kind of walk through those comments from the Department of Water Resources. I see that most of that was addressed, but I'd like to get that on the record.
Thank you, Commissioner Layden, and thank you all commissioners for your service and staff for your due diligence. Andrea Cole, C-O-L-E, General Manager of Dominion Water and Sanitation District. We're located at 9250 East Costilla Avenue, Suite 400 in Greenwood Village. Thank you for that question. Yes, there was a little bit of a difference between when Division of Water Resources initially reviewed the application times back to what Commissioner Teal mentioned of the uncertainty of water supply for the range. And so those inconsistencies have been addressed. And then there was a little difference between the final acreage in terms of water being provided, and that was a nuance to the irrigation. And so we were able to clear that up. So we've addressed all those comments and concerns for the Division of Water Resources.
Okay, thank you, Andrea, I appreciate that. And so irrigation of the common areas is being allowed by Dominion?
That's correct. And so you'll see in the agreement between Dominion and the range that there is a call out for an additional irrigation connection fee. So once it's closer to final plat and the range understands exactly how much common area they're going to have to irrigate, then we'll determine what that fee is going to be, and that water will be provided.
Okay. And it looks like the proposed water supply is going to be adequate and provided without causing injury to decreed water rights as long as the existing wells are properly plugged and abandoned. So that we have that commitment as well.
Yeah, that's correct. We do not intend to use any of the existing groundwater wells on the range. There is potential in the future to drill wells, but that is something that would be much further out and would be part of Dominion's conjunctive use system. We have all the water supply that we need today in order to provide the water to our existing customers as well as the new development, which is also covered in the agreement. You'll notice that there's a cash in lieu payment that the range has to pay $40,000 an acre foot for the full 137.5 acre feet of water. And that's part of the commitments that the range has brought to the table. And Dominion will utilize those funds to go and procure additional water resources to firm up the supplies that we have available.
Okay. And I guess my last question might be around the management of the stormwater detention facilities. Do you want to walk us through that?
That is not Dominion. I'll have to refer back to the range.
Okay.
Sorry.
No problem. Thank you to Dominion. Appreciate that.
Yes, Commissioner Layden. The stormwater detention facility's primary ownership and maintenance responsibility will be the Range Metro District, with secondary capabilities for the county as an easement over the detention facilities to be maintained by the county should that need ever occur.
Okay. How likely is it that that need would occur?
Not likely at all.
Okay. I think those are all of my questions. I'll go back to the board and ask if anything was triggered in your mind. Any additional comments?
No, appreciate the additional question for Dominion.
Okay, great. Anything else, Commissioner Van Winkle?
No, ditto.
Okay, great. So thank you. I'm going to open it up for any citizen comment. Is there any citizen comment in the room with regard to this item? Yes, if you want to come up to the podium and just state your name and where you're from. You'll have about 3 minutes for your citizen comment.
My name is Randall Poet, spelled R-A-N-D-A-L-L, P-O-E-T. We own the property at 7680 North US Highway 85, Sedalia, Colorado 80135. The range property is adjacent to our south and east. We have had multiple emails and several in-person meetings with various members of the range team to discuss the range's need for portions of our property to enable their subdivision and to discuss several requests we've had with them to limit the long-term effects on our property. Discussions have been constructive. Topics discussed have at times been very detailed because we'd like the issues addressed and resolved before the development is finally approved so that we do not have any lingering issues that need to still be addressed in future years, especially because current parties will no longer be involved, and then including possibly not us and the range as well. Our remaining issues are appropriately covered in a letter from the range to the county dated on April 19th, 2025, supplemented by our letter and email to Mike Prosica on May 2nd, 2025. We were working on 4 requests for the Douglas County Board of Commissioners, some of which are already partially addressed. Regarding the water and wastewater service agreement between Dominion and Range Metro Districts, we received the agreement at 11:30 this morning and haven't been able to more than scan it. However, we understand from a phone conversation with Brian Horan this morning, there is no provision for any future well setback from our current property line on the current range property. My wife will review this more in her comments to the board, but we request the commissioners require a 1,000-foot setback from our current property line to any future wells that might be drilled on the range property. Second, regarding acquisition of approximately 1.5 acres of Poet land associated with the range's northern access road, we request that the commissioners require we continue to be involved, in the discussion and any pertinent agreements that are executed prior to final plat approval. Number 3. Because deeding approximately 1.5 acres of our property to the range for their northern access will eliminate our ability to access 85 at the Airport Road intersection, we request the commissioners require an access agreement of some sort or some sort of easement to be developed and executed prior to the final plat approval so that we have future access to 85 and the airport, at the Airport Road intersection from the southern portion of our property. CDOT, during the earlier phases, during the rezoning phase, that was indicating that we would end up being provided access along that stretch, and we are losing our frontage to the road. So there goes the road.
And sir,
and
you
beyond
are
that-
a bit over time. If you can wrap up your comments.
Okay, and again, this other one is good. We are working with the range on the sewer and water routing, and that's still to be finalized, but it's being worked on. So thank you.
Thank you, sir. Appreciate that. Additional citizen comment. Yes, ma'am. Welcome.
My name is Susan Poet, spelled S-U-S-A-N-P-O-E-T, and together with Randy, we own the property at 7680 North US Highway 85, Sedalia. The range property is adjacent to us on our south and east. I want to share with you the reasonings for our request for a 100-foot setback of future wells on the range property to accommodate a future well on the southern portion of our property. There are two aspects of our request for this setback. There is an engineering or legal aspect, and then there's the human aspect of our request. The engineering legal aspect of the request is that we understand from Dominion at the Planning Commission that they would most likely drill wells into a much deeper aquifer than we would use for a future well supplying a single-family home on the southern portion of our property. Our own water consultant has indicated that although a well accessing a deeper aquifer on paper should not significantly deplete the water access from a shallower aquifer 600 feet away, in reality, depletion of shallower wells does happen when high-volume, deeper wells are only 600 feet away in many groundwater areas. The consultant has advised us that it is now common to have 1,000-foot separation between wells to delay the depletion from nearby wells. Thus, our request for a 1,000-foot setback rather than a minimum 600 feet separation. If Dominion were to drill a well near our southern property sometime in the future, as indicated in the original Range Metro District application, our ability to later drill a well would almost eliminate our ability to drill a useful well, for example, for a future home on that portion of the property. The natural location for a future home on that portion of the property is at a higher elevation, which is near the southern edge of our property. I have a sketch, which I'm happy to give you, where that shows that we'd be limited to putting in a new well if Dominion were to drill a well near our southern property line. Because of the topography of that area on our property, any new well on the southern portion elevations of the any new well on the southern portion of our property would end up being in the lowest elevations of our property. So exceedingly more difficult and expensive to supply pressurized water to a future home in to the naturally better portions of the area. So although the law requires a minimum 600-foot distance to a new well from a current well, we are asking for a 1,000-foot setback. The human aspect of our request. We understand that we should be informed if and when Dominion might apply for a well permit in the future. 15 to 20 years from now, in all likelihood, the Poets are the only ones in this room who will be involved in a discussion of future wells on the range property. Given our current ages and our parental history of diminished mental capacity in their 80s, we are appealing to the commissioners to appropriately address this well setback issue now, rather than us dealing with the issue 15 to 20 years from now. We do not want to burden our younger family members with dealing with this issue sometime in the future. We've asked for a 1,000-foot setback from our current property lines to the future wells. Other than a statement of, quote, not necessary to our request, we've heard no alternative suggestions from Range's discussions with whomever they've been discussing on our behalf. We're open to alternative plans, but we desperately want a suitable solution put in place now rather than pushing this issue to our children's generation. Thank you.
Thank you, ma'am.
And I'm happy to give you my sketch.
Sure, if you want to approach council, he can label that as an exhibit and enter it into the record. I'll ask for any additional citizen comment. Any additional citizen comment? Okay, not seeing any in the gallery. I'll open it up online. Any citizen comment online?
Thank you, Commissioner. I have no online comment.
Okay, with that, I'll close citizen comment and bring it back to the board for further discussion and or a motion.
Thank you.
Okay. Chair, well, I'm actually pretty pleased with what we see before us from the Range development team. Again, I think about that zoning that we did and how it was just made very clear. I mean, I think I'm the one that made it clear that there were things that the Range did need to work out per our regulations in order to come back to us for this day and for this plan. I'm seeing those satisfied. I know I do understand the Poets and where they're coming from, with their additional requests. I guess my consideration is just along the lines of, if it was multiple residents making these additional requests over and above our regulations, I may be more sympathetic, more interested in acceding to them. As is, I'm seeing superb work being done by this development team coming before us. And so if it pleases the board, I do have a motion to approve range preliminary plan because it does meet all the approved criteria with 13 conditions as presented. Project file is SB 2024-048. The conditions reflect the condition number 1 that has been satisfied with the partnership with Dominion.
And Commissioner, thank you for that. I'm going to ask you to hold that motion for just a couple of procedural items. First, I wanted to ask the applicant if the applicant is okay with all the conditions as presented.
Yes, sir, we are.
Okay, great. And then I also wanted to make sure you had an opportunity to respond to any of the citizen comment that you heard.
Yes, sir. I would believe the 4 initial comments submitted by Mr. Poet, I believe their points 2, 3, and 4 are captured in conditions of approval. 3, 4, and 5, I believe it is, their points. And then as it relates to the well setback, we do have Andrea Cole here, as well as the county water specialist that could answer to that as well. It's not our decision for the well location. It'll ultimately to be Dominion's, and there is a process that they will go through with the state, Colorado Water Resources, and maybe Andrea can explain that a little more for some background.
Great. Ms. Cole, did you want to explain that?
Thank you, Commissioner Layden. I think there's a couple things or a couple points of confusion, and it goes back to Commissioner Teal's earlier question, right? The initial application did consider a mixture of groundwater and surface water from Dominion being provided. That is no longer the case. So Dominion will be providing water from our conjunctive use system, which as of today is 100% renewable water. There are no immediate plans to do any groundwater work at all on the range development area. I think additionally, this kind of starts to get into the nuance of where the state has that presence as a state issue to protect and ensure that folks' water rights to include groundwater is not being impaired. And so that's where that 600-foot setback comes from a well to well site. And when you drill a well, you have to get a well permit. That permit goes to the state. They review what you're doing. They review the aquifer characteristics. They go much further than that 600 foot, right? So they do a bubble and they determine which wells are in that area, what the cone of influence is, and then they'll tell you like how much screen you can have in your aquifer. So there's a saturated thickness within the aquifer, which is where the water comes from, and that is where you screen to pull that water into your well. So for example, when Dominion drilled our well at Cherokee, which is not equipped, we just drilled it so we could determine quality and quantity of the aquifer at that site. We filed our permit. Again, even though it's not equipped, we still had to get a permit for the drilling activities, and the state requested that we remove 100 foot of screen from our design because they felt that there could be impairment to Sedalia as well, which does have a lot more users on that well, right? And so we complied and took out that 100 feet of screen so that there was no impairment. And I'll note that that Sedalia well is much further away than that 600 foot. So this is an area where the state is very active in making sure that folks' rights are not impaired.
Andrea, thank you for that. And while I have you, and maybe for the applicant as well, so one of the questions that got brought up was confirming that the water line between the Sterling Ranch Cab and Louviere's Water and Sand is adequate for fire flow.
That's correct. So it's not necessarily the line, it's the tank. And so that's why there will be a tank on site at the range to help provide that quantity of water supply should there be a fire at that location.
Okay, thank you for that. And thank you, Commissioner Teal, for allowing the applicant to provide just a little bit additional clarification in response to citizen comment. I'll turn it back to you for further discussion and/or a motion.
I believe the motion was recorded and it is restated.
Okay, I'll accept that motion. Is there a second?
Thank you, Mr. Chair, and I very much appreciate the response and details about a potential well, or actually lack thereof, is what it sounds like, and the standards that would have to go through, which is a whole separate process from this, and therefore I second this motion.
Okay, thank you. So we've got a first and second on the floor. Any further discussion? You know, I'll just add, walking through the legal approval standards under 403, it really appears to me as though all of these items have been satisfied. And in reviewing the packet and hearing from the applicant, as well as the additional comments, I tend to agree with my colleague that, you know, what this really represents today is great regional partnership. And for a county of 400,000 that has water needs and, of course, is becoming one of the most quickly growing counties in the United States, it's really wonderful to see all the partners coming together really well to make sure that this community just comes out of the ground in a really positive and sustainable way in the future. So certainly excited about that. And again, from my perspective, it looks as though all the approval standards have been met. Any further discussion? Seeing none, all those in favor signal by saying aye.
Aye.
Aye, and that passes unanimously.
Thank you very much.
Great, congratulations.
Mr. Chair,
Yes, sir.
1 minute.
You bet. You know, we're going to take about a 2-minute recess. We'll reconvene in a couple minutes here. So we'll go ahead and call this meeting back to order. Thank you for your patience. Our final item today is item 3B, which is Castleview Filing 1, Second Amendment, lots 1A and 2A, use by special review, project file US 2024-009. Matt Jacobowski presenting for staff. Hi, Matt.
Good afternoon, Commissioners. Matt Jacobowski, representing Planning Services. The applicant is proposing a use by special review for a 317-unit multifamily development. The project number is US 2024-009. We have Lane Gearhart of the Garrett Companies here, as well as his team and professionals. The request is for a 317-unit multifamily development on a 12.6-acre site within the C Commercial Zone District. Multifamily development within the C Commercial Zone District is allowed subject to a use by special review process. The proposal also includes a request for an alternative parkland dedication standard for the proposed multifamily use, as may be required per Article 10 of the county subdivision resolution. The intent of the USR process, as set forth in Section 21 of the zoning resolution, is to provide for uses in specific zoning districts that shall require a public notice and hearing and the approval of the Board of County Commissioners, subject to such conditions and safeguards as may be imposed by the board. The use by special review process begins with the submittal of an application. Following a review period by referral agencies and the public, notice is given for public hearings before the Planning Commission and Board of County Commissioners. All referral comments received are attached to the staff report. Referral comments were technical in nature, addressing traffic, drainage, and other engineering requirements. Per request of the Centennial Airport Centennial Airport Authority, this proposal is within the Centennial Airport review area of Douglas County. The applicant has agreed to record a navigation easement over the property. The applicant also received letters of no conflict from the FAA regarding project design, which generally relates to the height of the building. There are some height restrictions for the property, although there are no noise or safety restrictions per the CARES standards in Douglas County based on its location. So again, the FAA indicated no objection to the height of the building. They're within the parameters of height. Though not part of the Inverness or Meridian metro districts, the applicant communicated with those districts to assure design compatibility. The applicant also received approval from the Community Development Director for a parking ratio specific to a multifamily use near mass transit. The applicant is receiving water and sewer from the Inverness Water and Sanitation District extraterritorially. Staff received 2 public comments on the day of the Planning Commission hearing. These comments were provided to the board in a packet of additional documents sent on May 22nd, this past Thursday. These comments object to the proposal, indicating that residential development should not be constructed near Centennial Airport due to safety and noise complaints. During the review process, the applicant separately communicated with an adjacent property owner and worked to resolve that neighbor's concern. That comment is in the staff report as well. The Planning Commission heard the request at its May 19th, 2025 public hearing and recommended approval by a vote of 8-0. Planning Commissioners asked the applicant questions related to proposed noise mitigation, which is related to its location adjacent to I-25 and E-470, as you'll see on some maps that I have coming forward here. The Planning Commission also asked the applicant about their communication with Centennial Airport and asked questions regarding parking and pedestrian and traffic safety. One member of the public spoke at the Planning Commission hearing, indicating that residential development should not be constructed near Centennial Airport due to safety and noise complaint issues. The site, identified by a red star, is very near County Line Road, approximately at I-25 and E-470's interchange. The site shown here in blue highlight is again located in the C Commercial Zone District, which are the red areas. You'll notice, for context, County Line Road to the north, I-25, E-470, Park Meadows Mall. The County Line light rail station is approximately 1/3 mile walk, and it's actually accessible by a pedestrian bridge over I-25. The aerial better shows some adjacent land uses. 2 existing multifamily developments are located to the southeast. An office development is located directly east, an auto repair directly to north, and the existing Grace Chapel Church to the north. Grace Chapel is owner of the properties. It's under contract for the proposed development. So Grace Chapel has had these parcels in which this proposed development is to occur for quite some time. The property was zoned C commercial with the inception of zoning in Douglas County in 1955. Initial platting occurred at that same time, but replats were approved in the early 2000s to bring the parcels to their current configuration. As I mentioned, the parcels had been owned by Grace Chapel. There were some site plans that approved parking on both sides of South Valley Highway. However, the only place in which that parking was developed was the west side, closer to the church. Before you use the applicant's USR site plan exhibit, north is to the left. Access from South Valley Highway, which bisects the site. The parcels east and west side include 3 buildings on each side. The applicant has proposed private recreational amenities on the west side parcel. There's a clubhouse, fitness center, pool, and dog park. Note that a sound wall is also proposed along I-25 adjacent to the dog park and those recreational areas. Parking access occurs in 4 locations. Surface parking spaces are proposed. A detached garage is proposed. Tuck-under parking is also proposed within buildings to accommodate parking for residents. It should also be noted, with its unique configuration of having the development on both sides of the site, that a pedestrian crosswalk with a flashing beacon is proposed across South Valley Highway to allow safe access from the east side to the west side, especially for those that might be using the fitness center and those facilities. In addition to a plan exhibit, use by special review applications require what's called a management plan that provides an indication of maximum units, employees, parking, and method of fire protection. That is on sheet 1 of the USR exhibit. Shown here are typical elevations of multifamily buildings and an elevation of the clubhouse. The buildings are similar in scale and have a consistent architectural theme, as you can see here. Due to the site's location adjacent to I-25 and E-470, buildings on the west side will include noise-rated wall, roof, and window materials to manage interior noise levels. So again, the noise is being mitigated in those situations due to the highway and its location adjacent to I-25 and E-470. Following our site photos, this is a view from the west side of the site and the parked area that Grace Chapel utilizes for some overflow on the north side. So you can see, looking south, you can see the E-470, I-25 flyover. You can also see adjacent multifamily development. This photo in the reverse is from the south side of the west parcel, looking northwest, roughly from the driveway of the adjacent multifamily building. In the distance, you can see the pedestrian bridge over I-25 that provides access to the County Line Light Rail Station. Flipping to the east side parcel, this view looks north through the site. On the right side of the slide, you can see the shadow of the adjacent multifamily development. This view, flipped to the other side of the east parcel, looks south through the site, and in reverse you can see the multifamily building that I just mentioned. That's on the east side, and then the other multifamily development that's on the west side. In regard to the applicant's proposed alternative parkland dedication, Subdivision Resolution Article 1003.01 allows the board to consider alternative parkland dedication formulas for multifamily development proposals. Applying the standard to the applicant's proposal, it would require a land dedication of 14.265 acres, which is greater than the size of the site. The site is only 12.6 acres. Then further applying the appraised value per acre of about $690,000, that would equate to $9.8 million in cash in lieu fees, or $31,000 per unit. The applicant submitted an alternative parkland dedication analysis proposing a land dedication of 2.996 acres. I should add that in staff's research of previous platting, approximately 6.5 acres of land already provided a cash in lieu of land dedication. Therefore, staff has considered a credit from those previous payments, being that we wouldn't double dip on an applicant, which would then, if that credit were applied, bring the park land dedication to 2.801 acres. And instead of the $2,068,425 that the applicant calculated in its alternative, a credit for again that previous platting process, it would bring the cash in lieu payment to $1.9 million. The applicant asserts that there will be adequate park facilities to meet the needs of its future residents based on reduced household size and park usage and the provision of on-site private recreational and amenities. And again, that includes fitness center, clubhouse, dog park. The applicant has also proposed a 12-foot wide sidewalk on the west side parcel per some comments from engineering through the process related to an interest in providing a multimodal corridor for bikes and pedestrians. So with that, the applicant has provided that information and has some slides in its presentation to provide some additional analysis as might be needed. The approval standards for a USR request are set forth in section 21 and listed on this slide. Staff's assessment of the approval standards are discussed in detail on pages 8 through 11 of the staff report. Staff has evaluated the use by special review request in accordance with section 21 of the zoning resolution. Should the board find that the approval standards have been met, the following proposed conditions should be considered for inclusion in the motion. Condition number 1, prior to the board hearing on the USR, the required USR improvements agreement and public improvements agreement shall be approved. Condition number 2, private recreational amenities proposed on the USR exhibit shall be identified and secured through the USR improvements agreement. Condition number 3, prior to final approval of the record copy of the USR plan exhibit, the applicant shall record a navigation easement to be dedicated to the Arapahoe County Public Airport Authority. Condition number 4, prior to final approval of the record copy of the USR plan exhibit, secondary drainage easements, general purpose utility easements, and sidewalk easements identified on the USR plan exhibit shall be accepted by the board and recorded by separate document. Condition number 5, prior to final approval of the record copy of the USR plan exhibit, the existing storm drainage easements at reception numbers 2005-016-022, 2005-016-023, and 2005-016-024, identified on the USR plan exhibit, shall be vacated by separate document. Condition number 6, prior to the first building permit for the development, the applicant shall provide cash in lieu of 2.801 acres of parkland dedication in the amount of $1,933,782. Condition number 7, prior to the first building permit for the development, the applicant shall provide payment in the amount of $361,119 to the Douglas County School District for cash in lieu of land dedication. Condition number 8, prior to final approval of the record copy of the USR plan exhibit, any necessary technical correction shall be made to the satisfaction of Douglas County. And condition number 9, all commitments and promises made by the applicant or the applicant's representative during the public hearing and or agreed to in writing and included in the public record have been relied upon by the Board of County Commissioners in approving the application. Therefore, such approval is conditioned upon the applicant's full satisfaction of all such commitments and promises. Section 2109.09 of the zoning resolution sets forth the parameters for the board's decision on USR requests. This concludes staff's presentation. I'm available to take questions on the staff report if the board wishes. Otherwise, Lane Gerhardt of the Garrett Companies is here as applicant with the Garrett Companies team.
Great. Thanks for that presentation, Matt. Any questions for staff?
I do have some questions,
Sure,
Mr. Chairman.
Commissioner.
And allow me to start with the parking question, which is how many parking spots would typically be for an apartment complex of this size, and how many are actually being proposed in this, what's presented before us today?
Matt Jacobowski for staff. The parking requirement is 2 spaces per unit. The applicant's proposal, which was an alternative approved by the planning director, was 1.8 spaces. So they're sitting at 582 when 643 would have been the requirement. So not that much off from what would have been required. What was, I thought, impactful analysis by the applicant in their alternative parking analysis was an actual field count of parking lots at other sites similar to this in the county. I believe 4 in Castle Rock, 3 in Lone Tree. They made the count during overnight hours, 3 a.m. to 5 a.m., and saw that actually they'd be well within the range of the actual on-the-ground spaces in that analysis.
Okay, so that's based more on real-world examples that were recorded during the high parking times of other similar structures, not necessarily the light rail station, which frankly is quite a hike away.
Correct. I think what's interesting is even though I'm sure there'd probably be some folks that would use the light rail station, what I found impactful was that they counted spaces on the ground of sites that weren't necessarily as close to the light rail. So regardless of situation, I think they are able to meet the alternative, and our director approved that with those reasons in mind.
Okay. And a second kind of line of questioning goes back to there was some time dedicated to the cash in lieu for parks, which under our Article 10 standards, I believe you said would be $9.85 million, but that was reduced to $2.07 million and then further reduced to $1.9 million. Could you help me understand, or maybe just walk through that one more time briefly, how the Article 10 standards were essentially do not apply in this case?
Well, Jeanette Baer for staff. It's not that the Article 10 standards don't apply. What Article 10 allows for is for applicants to request an alternative parkland dedication standard for multifamily projects. And multifamily projects, I think, make an argument that they have a lower household size, therefore they don't generate as much demand for parks as a single-family detached dwelling. That's one of the reasons. And then, of course, I think the applicant has been following kind of the county's thought process on potential amendments to Article 10. Right now, we require 15 acres per 1,000 residents, which is nearly double what other jurisdictions do. So I know the board will soon be looking at that and determining whether they want to move that forward to referral using a standard that's more like 8 acres per 1,000 residents. So they also looked at other jurisdictions and have made the case that this is more in line with what's typically required, and I think that's what you saw on one a couple weeks ago as well. So they're able to ask for this discretion from you, and it's up to the board to decide.
Okay, thank you. And you also mentioned that there was a previous park dedication that...
We did, we brought a similar request before you. I don't know, I want to say it was about...
No, I mean from this specific site, a previous owner of the site or the church?
Oh, well, back when they did some replats early in the 2000s, at that time it was non-residential use, and they paid the equivalent of 3% parkland dedication cash in lieu that was required per our regs. So for non-residential right now, they have to pay 3% of the gross, they have to dedicate 3% of the gross acreage to parks, and they paid cash in lieu back in the early 2000s. So we gave some credit for that, or suggesting that you could give some credit for that.
And would that have been when the church was built?
Right, because at that time multifamily is allowed through use by special review, but they were all zoned commercial, I think, at that point. So that's why the 3% was applied at that time with the replats, because I think it was for parking is what was being proposed, additional parking for the church.
Okay, thank you.
Thank you for that line of questioning, Commissioner. That triggered some thoughts in my mind. You know, I am not at all interested in deviating from the requirements of Article 10, but I think what has been interesting to the board is the functional equivalent of recreational amenities interior to the multifamily. So where there are those plans in place to create that equivalency for the intent associated with Parkland, I think that does make sense. So if you're talking about that sort of line of thought from the board, I certainly would support that. I'm not sure, was that satisfied in this application?
The request includes private on-site recreational amenities as well that they're asking for credit for.
Which
and
is
they can explain more on that.
okay, and I might, when the applicant's prepared to give their presentation, maybe we can get into some additional detail. Any other questions for staff? Okay, none. Any else? Okay, great. So we'll have the applicant come up. If you want to make your presentation, we might have some additional questions for you.
Good afternoon. While Matt's pulling that up, my name is Lane Gearhart. I'm a development manager with the Garrett Companies. We're at 5075 South Syracuse Street in Denver. I'm a Denver resident as well. So I'll give a little more context, just who we are as the Garrett Companies. We were founded about 10 years ago, and in that time have delivered almost 6,800 units across 40 projects nationwide. More than half of those are here in Colorado. We opened our first office here in 2021, and of our projects currently under development, more are half. So we are a national company, but really a heavy presence here in the Front Range and a local team running this project here. So you'll see a couple of familiar slides. I'll go through these kind of quickly. We are at the north end of the county at E470 and I-25, highlighting the existing conditions Matt spoke about. There's nothing on this site currently. It's an empty grass field. That's literally where the sidewalk ends from our adjacent properties. Looking to the south, you can see those multifamily projects he talked about. So nothing there right now, but we believe it is a neighborhood that strongly supports the idea of multifamily housing here in the county. Wanted to highlight a few of those amenities. Our site is shown here on red, kind of at the bottom of this image, and we're about a 15-minute walk from John Derry Park, 15-minute walk from Park Meadows, 10-minute walk from the County Line RTD station. And we view our project as a way for both our residents as well as those adjacent residents to really connect to those. As I mentioned, right now, the affordable housing complex to our south, there is not a way for them to get there. The sidewalk ends and they have to either walk in the road or through the grass, and we're proposing a 12-foot wide multimodal trail for bikes, pedestrians, scooters, kind of other ways to get to these and really continue to grow the community. I know you asked about parking. We did have a comprehensive analysis from our consultant. Their information justified a 30% reduction in parking, which is not something we think is reasonable. So what we asked for and was ultimately approved was just under a 10% reduction is where we came to. And then just highlighting I know the zoning map showed that this was all heavy commercial and light industrial currently, but there are a decent number of multifamily projects, both existing and approved for this area. It's really changed over the last 20 years from when Inverness was initially set aside, and we believe that our site is a great location to continue this residential development within the area. Something else we just wanted to highlight, this is not an income restricted project, but our projected rent levels are at about 80 and 90% AMI for nearly all of our units. We view this as something, we call it kind of the missing middle, but it's intended for residents that live and work in the county to really be an accessible housing project. Getting into our site plan in a little more detail, Matt mentioned we're pretty evenly distributed across both sides of South Valley Highway, 317 total units, 3 residential buildings on each side, and the amenities kind of focused in that southwest corner. I'll talk about those a little more in a later slide, but I did want to highlight on this one that as Matt mentioned, we spent a lot of time working with Inverness and Meridian, going through their thoughts on this project. I think our initial submittal to Inverness was in June of last year, so it's been almost a year working closely with them. Through that time, we've refined detention pond locations, retaining walls, heavy focus on trees and landscaping, and really making sure that what we're proposing matches the existing community and what those folks want to see as they've been building this community for the last 20 plus years. Slightly prettier version of our building. It's a mix of stone, fiber cement panels, heavy balconies, a lot of landscaping, and a heavy focus on kind of native and regional plants along the highway to really give an attractive front door to the project. And then focusing on the clubhouse that we do see is kind of the center of life for the project. We have our pool area there. It's going to have our fitness center, resident leasing area, dog park, something for all of our residents to really thrive and enjoy living in this project. And then one more thing I wanted to touch on was noise mitigation. As Matt mentioned, we have upgraded our glazing and wall assemblies on the west side of the project to ensure that those residents are shielded from that highway noise and providing a comfortable standard that meets ANSI, HUD, and other regulatory kind of guidelines. What we're highlighting in these images, that yellow line is kind of the 65 DNL threshold. That's often the area where noise mitigation becomes necessary outside. We're proposing a 110-foot long noise wall along our amenities to make sure we're pulling that sound level out so that folks enjoying those outdoor spaces are not listening to the drone of traffic the whole time they're out there. And I know he mentioned the airport comments as well from our Planning Commission hearing. We are not in the noise sensitive zone. We're not in the noise restrictive zone. We are well outside of their 60 DNL buffer. So we feel good about where we are from a sound standpoint. And we've met with the airport during our referral period to ensure that we're providing navigation easements, working with the FAA and checking those other boxes that they wanted to see. And then a little more information on the park's dedication standard. These numbers are reiterating what Matt referenced. The current fee is greater than the appraised value of our site, just by nature of how the county's multifamily standard works, or I think highlighting that there is not a multifamily standard and that single family and multifamily have the same calculation. The county assumptions are that there's 3 residents per unit, which is just not something we've seen in our typical multifamily projects. Looking at projects in this area, I think looked at about 10 or 15 that we've delivered over the last few years. We see about 1.8 residents per unit, which is nearly a 40% reduction from those county standards. And again, that's consistent with what we've seen looking at other jurisdictions, just trying to understand how they calculate these fees. Highlighting again those on-site amenities that we discussed. We have a fitness center in our clubhouse. We have a pool. We have an outdoor kind of grill, barbecue station, game lawn, dog park, our access path. We have some dog runs at our private units, intending to build space in this community for the residents to reduce that demand on parks, that people aren't going, they have spots to walk their dog, they have spots to play, to really focus this in on the site and ensure that we're doing what we can to limit that demand. And so this slide, just kind of highlighting some of those questions about how we arrived at that fee, showing the required fee up top, our proposed reduced value based on demand, lower resident count, and different assumptions in the units, and then a credit for those on-site improvements to get us to the 2 million number. That doesn't include the credit for the previously paid fees. But again, highlighting this is consistent and actually on a per unit basis a little higher than some of the other projects that have come through recently. And it's really something we need for this project to be financially supportable, frankly. If we have to pay that full $10 million fee, this project won't be able to get off the ground from our standpoint. And then just wanted to highlight, we are requesting a deferral of the school fees. We're not requesting a change in that payment. We're perfectly happy to pay the full fee that the school department has requested. And so lastly, just kind of a summary that we do believe that we are in compliant with the USR criteria and that this is a great location for multifamily housing. We're meeting the minimum zoning requirements. It's in an area identified as the primary urban area on the master plan, and we're creating a kind of walkable community that can really mesh with the existing environment, and have gone through extensive reviews with the neighbors to ensure that what we're proposing fits the character of this area and community. So I have all the individual criteria up here. I'm not going to read through them unless you all want to see them specifically. But if there's any specific points you want more information on, I'm happy to answer those in more detail. So thanks for your time, and that's my presentation.
Great. Lane, thank you so much for that presentation. Any questions for the applicant?
I have none.
Thank you, Mr. Chair. To the parking question, it does say, and it says that Grace Chapel currently utilizes this space for overflow parking, so they'll lose that, which is, I think, it might be their issue much more than it is your issue going forward. But it does present questions around the parking size. And then it also says from South Metro Fire that 37 spaces are, tandem spaces are only available to church leasee. So in your calculation for parking, are there's 37, I found the reduction from 2 per unit to 1.8 units somewhat compelling. It just seems South Metro Fire doesn't completely agree. But what's the deal with those 37 parking spaces? Are those included in your current calculations, or are those belonging only to the church?
So we do have some tandem spaces on site. And to address South Metro's comments, that was in their initial comment letter. We met with them after the fact. Their biggest concern is that people are going to be parking in the fire lanes, which will restrict fire trucks to get through, which is obviously something we don't want either. We're very, we manage our communities. That's something we just won't let happen. And whether it's towing, ticketing, some other method, we'll ensure those routes are clear. So we did meet with South Metro to address those comments. And they, I believe, provided a second letter of support confirming that we had met their concerns on that front.
Okay. Well, I certainly do appreciate that clarification. But so 582 parking spots will be on site. Of those, 37 will be, I'm guessing Sunday morning, probably the church will like to use those.
I don't, there's none that are intended to be for the church. The church is actually relocating. The current church site is also being sold to another developer.
Okay.
So the church's intent, they're looking to grow and moving to a new location, so the church will not be using any of those parking spaces long-term.
Okay, thank you.
Sure.
Thank you, Commissioner. So a couple questions. I want to go back to the airport noise issue, and I'm walking through the comments from the Arapahoe County Public Airport Authority. This is my district, so I can verify that residents in your complex, if approved, will hear a lot of overflight noise, a lot. I mean, early morning, 5, 6 a.m., and then past midnight, sometimes every half hour. I can verify that personally. So one of the comments they made, I really do appreciate that you are proposing the navigation easement over the site to be recorded as a condition of approval. So that I just want to confirm that that's something you want to do.
That's correct. And we'll also have language in the leases that residents acknowledge they're living near the airport, so there's no surprise when folks show up and hear an airplane.
Yeah, I'm a big private property rights advocate, and one of the reasons units like this are more affordable, or it's better for workforce, is because it is closer to the highway, it is closer to the airport. So they're getting a great product that is maybe a little bit more affordable, and so it's not going to have maybe some of the same amenities as other locations. But that said, anything that the parties can do to make sure that they're reducing that noise, I think is always appreciated. So one of the comments they made is if approved, verified noise attenuation at or below 45 decibels would be provided. Is that something that you've agreed to as well?
Yes, we've agreed to meet those noise standard requirements.
At 45?
And I believe that's already met by our.
Is it?
We have our acoustician here. I can double check those numbers with him, but I believe what we're projecting is below the 45
Okay.
interior.
Yeah, if you can confirm that, I think that would really help with the airport items. Maybe while you're looking that up, can you go back, Lane, to that slide that you had about the calculation on the parks?
Sure. Sure.
About the noise issue, it's Jeff Surgeon Acoustics. I did the analysis, I did the modeling, and we were below 45 dBA DNL inside the apartment.
Okay.
We're actually below it, much more below it in most cases.
Oh, great. Okay, that's actually really great news. Thank you for doing that. Okay, so I'm looking at this breakdown here. So it looks like the recreational amenities being provided on site, it's going to be about 1.375.
That's correct.
For those. Okay. And then walk me through the reduction in assumed residence. So you're saying our regulations assume 3 per unit. Experience would say what per unit for you all?
About 1.8 is what we see.
About 1.8. So that reduction results in a $6.4 million reduction?
It's a mix of number per units as well as the standard we were discussing earlier. The county standards are about 15 acres per 1,000 residents. And just that demand, I think what we've seen historically is lower in some of these multifamily and other jurisdictions at closer to 6 to 9 units, 6 to 9 acres per 1,000. So it's a mix of the number of people as well as how much parks, open space those individuals are using. And so
Okay. I'm not interested in modifying our regulations based upon what other counties are doing. Obviously, we put a high value on recreational amenities, open space, and parks in Douglas County. I think that's one of the many reasons that citizens are moving here and not other places. So if you were to reduce that 3 per unit down to 1.5, what would that reduction number look like?
you're saying the 50% reduction?
Yeah. So if you're, 50% reduction, so it sounds like that'd be closer to what, 4,400,000? I guess, what would that be? 4,000,008?
4.9.
4.9, okay. I think for me, that would be much more acceptable. I think it's pretty demonstrable that the number of residents per unit would not be 3, and that it's more likely around that 1.5 number. But if we toss out any sort of, external jurisdiction equivalency, I think that's the number that would make more sense for me, but I'm just one. I'd be curious to know what that number is. So I guess that would be the difference between 4.9 million and 6.4.
If I can speak to that a little more.
Please.
I know, so some other projects have gone through this. I'm not, trying to do apples to apples. I think part of what we've done for the on-site improvements as well, we're trying to get to a number that we believe is a fair contribution here. I know a project came forward a few weeks ago that had over $4 million in credits for on-site improvements because they counted their entire clubhouse and those facilities. We're not trying to do that. We're not saying that building this $4 million clubhouse is truly an equivalent here, but we do think that there is a substantial demand reduction that comes from providing these amenities on site that greatly cuts down on what residents are using for those parks throughout the county. And I don't want to say that the numbers are fungible. I think we could allocate some of those cost allocations a little differently to be funny with the math, but that's not what we're trying to do here. We think that what we're proposing is a fair fee. It is frankly higher than some projects that have come through recently because we think that's what's appropriate, and we're trying to pay a fair share for this while also being able to commit to some of those rent levels and actually provide housing in this location.
Yeah, well, I agree that workforce housing is a big priority for us for sure, and we'd love to see more of that. That said, I think there's certainly a desire that's been expressed to me by citizens to avoid the cookie cutter, stick-built Minecraft apartments that you see all throughout Denver.
Sure.
Something a little bit higher quality that reflects, the quality of living that we have in Douglas County. I guess I would open it up to my colleagues. I mean, this is the danger of precedent, right? When we accept standards for one, we'll get future applicants that will refer back and call it precedent. I think it's well within our discretion to make some determinations here, but I'll just say for me that 6.4 number is way too high.
Why is it way too high?
I'm sorry, I missed that.
Well, you said the 6.4 number is way too high for the credit. Why is it way too high?
Oh, why? Yeah, well, I think we just walked through that analysis. I mean, he's integrating not only the reduction based upon not 3 per unit, but 1.5, which I would accept. But he's also arguing that because other jurisdictions have a lower requirement that we should adopt the same. So what I'm saying is I would adopt a reduction based upon 1.5 residents per unit. And we said that would result in about a $4.9 million reduction. And I'd be okay with a $4.9 million reduction, 6.4. I wouldn't be, and I think it's important that if you're not doing a park as a developer because you're multifamily, that you're creating recreational amenities that are the functional equivalent of that to some degree. And I certainly recognize that the needs of your residents might be different than other citizens in Douglas County, but I think all Coloradans that move here want to have some measure of recreational amenity. And you did show that. I mean, I think we saw some pools and dog parks.
Yeah, Mr. Chairman, that actually occurred to me also, the credit for the on-site improvements. I think when it comes to parks dedications, that was thought of for a long time in Douglas County and still is. It's, you know, a park that you can walk to and walk through, and you know, there might be a little lake with some ducks or fountains or something like that, and that's very different than, say, the needs of some residents, which will go towards, they do want that bench press that they can go and work out, and there, as opposed to working at one of the maybe nearby private gyms or something. I'm not sure that's an apples to apples transition, but it's something I've been mulling over here myself.
Yeah, that's a good point.
I guess my thoughts were, I found it compelling that the appraised value of the land is $8 million. You know, and so then you compare the fact that we were asking for cash in lieu of $9 million. Well, that's completely upside down. So then it goes to viability. So then a credit of some kind would probably be needed to make this pencil. Otherwise, it just stays an empty field at the end of the sidewalk. And so I think it's compelling to do something, not necessarily to fill the void, but along the lines of rounding out the rest of the neighborhood. So then it goes to, well, then how are you going to do that? And then, well, then my analysis went to what they're proposing for rents, and the fact that the majority of the rents are fitting within the 80 to 9% of AMI. Having a child who has done that analysis in real life in order to relocate closer to his work, you know, the reality is Douglas County was just not feasible for him. And it wasn't even that Arapahoe County was feasible for him. And so now he's a resident of Denver County where he could get that. So it just strikes me, you know, we could talk great about workforce housing, but it's these kind of calculations that help the development team to offer that kind of product for actual workforce housing. I mean, I think we've said it many times, Douglas County is a great place to live. You just got to bring a $100,000 a year check to it. And so for me, I saw where the proposed credit brought forward by the staff and the developer, I saw that as helping to bring that product online. All the while, it was product that would go ahead, as the developer said, you know, finish off the neighborhood. It wouldn't be the end of the sidewalk, stranding other multifamily further down the street without a sidewalk. So, and then, golly guys, I look at this location. This isn't, although, I was going to save this comment for the end. You know, the analysis on the parking, I really like that a lot. Having gone through in this town, when I was on the Castle Rock Town Council, the fact that we've got developers here pushing much further than 1.8 parking spaces per unit, strictly under kind of that same logic I was using here when talking about the parks dedication, cash in lieu. Because you push them much higher than 1.5, then they can't make the project. And it's not even affordable housing. It's not even attainable housing in terms of that AMI metric. So I feel like they're doing the right thing when it comes to parking. I was happy to hear that. They could just have thrown at us the fact that they're, you know, a short walk from the Metro District, and so applied like the downtown TOD metrics that we're hearing coming out of the Golden Dome every year, which are just ridiculous, and meaning that you can't own a car if you live in those kind of parking standards. So they're not doing that. So in terms of applying this, I don't know. This credit worked for me, Chair. And as a standalone, perhaps, and they had then cited economic reasons to lower that parking ratio even more than it is. Had they not had any sort of recreational amenities designed in, which we have seen, you know, Abe, you and I have seen those come forward in this vicinity here in the last 2 years. But these guys are planning for it. So from that perspective, I don't know. I guess I wasn't looking at it from a critical eye with all those other factors. And I thought this credit did seem reasonable. Large, there's absolutely no doubt about that, but reasonable. And there is a developed park in the area that has been in existence for years. They're a 15-minute walk away from it. So from that perspective, yes, would it be nice to have a larger cash in lieu fee that we know would come into the parks budget? We're at a time when we are doing major park recreational development. Would it be nice to have a bigger, you know, an extra digit on the left-hand side there, you know, an extra million, extra two? Absolutely. Yet at the same token, just strikes me they're doing so many other right things, it didn't seem excessive to me.
Well, thank you for that, Commissioner, and certainly appreciate your experience on municipal town council. I think that's certainly informative. Let me open it up for any citizen comment. Is there any citizen comment with regard to this item? Okay, not seeing any in the gallery. I will open it up for anyone online.
Thank you, Commissioner. I have no online comment.
Okay, thank you, Troy. So with that, I'll close citizen comment, bring it back to the board for any further discussion, questions, and or a motion.
Mr. Chair, I did not catch the total number of conditions presented. And perhaps we could go to that slide.
Matt Jukubowski for staff.
Nine conditions.
That's a good point, Commissioner Van Winkle, and I'll ask the applicant, are you okay with all the conditions as presented?
We are, yes.
Okay. Commissioner, did you want to see all those conditions?
Perhaps we could look at them one more time. Okay. Last one. Okay. Okay, thank you.
You bet. Can you go back to condition number 2?
Navigation.
Yeah. Okay, further discussion.
I guess the only other thing that's going through my head on this project, you know, we hear multifamily developments in our jurisdiction, in unincorporated Douglas County. Those come before us. We tend to have very large rooms full of people who are very angry about the proposed development. You know, Abe, I'll remind you, Kevin, I don't know if that's something you've picked up on. When it's up here in Meridian, I think so many of our residents kind of look at that location and say, yeah, that's where that belongs. So again, this just seems like a very reasonably constructed effort. I mean, I can remember when Grace Chapel out there was a car dealership, and you know, the full interchange wasn't hardly even built out because you know, C470 ended at I-25 before E470 was truly built out. So, I mean, I think this is land that we're seeing a community developing in that area, and it's probably very different than our other communities of Lone Tree. Our municipalities, probably very different than what we're seeing Highlands Ranch and Sterling Ranch. But we are starting to see that gravity building for community, residential community in the Inverness area. And it strikes me, I can't find a hard objection to the plan as proposed. I guess that's where I'm going to. And then I can't find a way that they don't meet the development standards. So it would be really, I just struggle to come up with any reason to say no.
And I do believe I largely concur with those statements. I do have a question. I feel like I missed the road capacity, those payments that we typically see. Was there any inclusion of roadway improvements, or are we not anticipating roadway improvements from the additional traffic besides that crosswalk?
Brad Jackson from engineering is online, and we could ask him. In this case, they did a traffic study, and they're putting in various traffic improvements, but so capacity was evaluated. But I don't know if Brad Jackson is online and could respond, or if he's running down here now
Not currently.
as we speak.
This is Troy, your host. He's not online currently.
Jeanette, maybe I can ask a second question that would probably assuage a little bit of the commissioner's question. Does Douglas County have a policy for transportation impact fees uniformly distributed across the county, or is it for specific developments only?
It's for specific developments only, specific circumstances.
Are there any existing transportation impact fee requirements within the Inverness development area at this time?
Not that I'm aware of.
Does that help answer your question, Kevin?
And my guess, and correct me if I'm wrong, is that the infrastructure has built up around this area to a point which the addition of essentially 500 new cars per day would not be heavily impacted.
That's correct. The infrastructure is in place in this part of the county. And you can talk more about the traffic improvements.
And so we have done the traffic study and found there's no impact to county facilities. We are making a contribution to the Inverness Metro District's fund for managing and improving the roadways within the district. That is part of our agreement with them as well. So there will be some contributions for the project from that standpoint.
Okay, well, that answers my question. Thank you.
Thank you for that, Commissioner. So going back to the approval standards and the legal criteria, I don't find that it complies with 2102.03 because it doesn't comply with the Douglas County subdivision resolution. I think particularly around that parks dedication that we're being asked to have some discretion on. I find it very persuasive that we are looking for workforce housing and that from a location standpoint, this is a good fit for that. So most of the other criteria here, I do think we are in compliance here, or the applicant is in compliance. So I certainly feel comfortable with most of these. But let me ask the applicant. So obviously, we're wrestling a little bit with this notion of the parks dedication. Is there a delta there that makes sense for you all that you would be interested in providing? Is that a hard number?
That's something I'd have to discuss further with the team. I think the 4.9 number would be too much for us to handle, frankly. Whether there's a smaller amount we could come up, there might be something there. But I think that's a $1.5 million jump that was proposed, I think would probably be too much for us to successfully underwrite.
Yeah. Well, thank you for that. Jeanette, yeah.
I wanted to throw this in just by way of background because we did do one of these about a month ago. And I think when we did the multifamily that was at that former Denver Athletic Club, they had about 325 units. They ended up with a cash in lieu contribution of $1.3 million, which was again about a 70-80% reduction. But I think the difference there was that they identified the cost to build the entire rec center component.
Right.
And that's why they had about $4 million or more in private improvement credits. For whatever reason, these folks said, oh, we don't want to do that. We're just going to cost out the improvements inside the rec center. So I think if they would have done something equivalent, they could have had a higher private improvement contribution as well. So I don't know that we're really talking apples to apples here. We're kind of talking apples to oranges, so I don't know if that helps. And that's why I think we'll have some discussions with you on potential future reg amendments to kind of set the set the rules straight if we're going to do this in the future, because I'm not sure we're looking quite at the same thing between those two projects.
Yeah, Jeanette, I
Yeah.
tend to agree, and that's, that's my old lawyer hat coming on and being concerned about setting precedent for the business community that may not necessarily be apples to apples. And I think that's a good example, not to bring in a prior application, but, obviously when we have blighted areas or areas that are in transition from a business standpoint, the county has a public interest in seeing that, highest and best use in that particular area. So this is slightly different. I don't mean to put you on the spot, and I might be outvoted. My colleagues might say, well, we want to give you that 70 to 80% credit. That seems really high to me. And to staff's point, I don't think we're talking apples to apples. So I'd be okay with perhaps a 60% credit. Because my colleague has persuaded me that, the workforce housing is certainly something that is being filled in this particular location. But for me, at the 70 to 80%, I would be a no.
Understood.
Mr. Chair, I did make a comment. Sorry. I did make a comment earlier thinking, and I think it assumed, or it could come across as assuming that the recreation being provided is basically a gym, a workout facility. Did I hear there's a pool?
That's correct. So there's an indoor fitness facility, there's a pool, there's outdoor kind of grill, barbecue area, there's we call it a game lawn, but where cornhole and that kind of stuff can happen, as well as a kind of private fenced-in off-leash dog park area as well.
Okay. Do you have a picture of that?
Are you able to change presentations?
Because I didn't want it to be assumed it was just the workout facility, which is important to as well.
Yeah, so the fitness facility we were discussing is inside the clubhouse, but down here is the full outdoor dog park and kind of dog run area. This area is we got grill stations, outdoor kitchen, seating area, fire pit, that kind of stuff. And then we call this our turf game lawn, whether it's bocce, cornhole, games of that nature that program for residents. Pool deck and area, we call this our spa. It's kind of a little hot tub and more seating area, and then some more kind of just open green space in that immediate vicinity as well.
Okay. Okay, thank you. I do appreciate that slide.
And it's a 15-minute walk away from an existing park. And I think that's a park managed by SpyMed or Meridian. I don't recall.
I believe it's Inverness.
Inverness?
Manages John Derry Park.
Okay. And it's 15-minute. I'm not sure I'm a 15-minute walk away from the nearest Castle Rock City, town park from my residence. And I get it, Abe. It sure would be nice to throw on another $1 million or $2 million that we could make use elsewhere in the county. I think there is that compelling need. Then I'm just concerned that, then we're preventing, we're making requirements that effectively prevent what otherwise looks like a right place and right item on the workforce housing market from going in. And it just strikes me, we haven't been big advocates of TOD. The three of us, transit-oriented development. Kevin, I've heard you speak against it on the Senate floor, I believe. Abe, you and I have had many conversations. That's not really what our focus is, unlike our colleagues in other counties, that we know that's their focus. And yet, here's a product that would be a really very great TOD-compliant housing product on the marketplace. Obviously, it's not our focus, but that does seem to be what's come before us. So, I don't know. I might vote you down, pal. I'm kind of okay with it. I do think we hit all the requirements.
Well, I appreciate that, and I'm a Denver native. I was born in Denver, fifth generation Coloradan, and I just, as a commissioner for 7 years, I see Douglas County very different than Denver, and again, the Minecraft apartments, that's not something that I think my citizens want me to vote for, and I'm not saying that's what's happening here. I think you have a really great design, and I certainly appreciate the nod to recreational amenities here. It is significant. The 70 to 80% credit is just too rich for my blood. So, and I think it sets a very dangerous precedent for the rest of the business community.
And Mr. Chair, I do think certainly absolutely no motivation whatsoever towards raising parks funds for the sake of just simply because it's something that may be needed in the county at this time. Much more motivation of the precedent which we are seeing set, or which we could be seeing set. This may be a one-time thing. I do have a little more personal leeway, just knowing this part of Douglas County is very different than really much of Douglas County. This is a part of Douglas County that frankly backs up to one of the busiest roads probably in the state of Colorado. Hence the noise wall for the lovely dog park there that I'm sure the residents will enjoy someday. I believe all that to say, Mr. Chairman, as a relatively new commissioner to the subject of land use, I will defer to further comments and further thought, and do appreciate all the hard staff work that has gone into bringing us to this point of what seems to be a thoughtful landing point.
And also, I mean, if I could just have an aside point of personal privilege, and just some direction to Jeanette and development staff. Understanding you guys are already working on amending these regulations that build out these cash in lieu standards for multifamily. When you bring that before us, can we please see the analysis of this project and how, again, possibly this precedent was set and what went into it, but then also what we saw earlier with the Denver Athletic Club, Colorado Athletic Club development, and the substantial credit that was done there. But also, I mean, we did have intervention from the dais on coming up. Our former colleague did some really quick math on the fly in order to come up with an alternative than what was proposed in the presentation, because even that was substantial. So if you could please take direction to kind of bring those examples before us when you bring those forward. And then, back to my colleagues, thank you for letting me get that to Jeanette, because I think that's going to be important for us when we talk about amending these regulations. Our staff is already working on amending these regulations. This very thing that has caused this very large credit that does have you concerned, Abe, staff's already working on an amended version because we already told them that, yeah, we'd like to see changes made there. So from that perspective, again, knowing that our regulations that have caused this point of concern are in flux, I still then go to the design, I go to the intent, and I go and I still see it as being reasonable. Once again, I don't see it as my view to get in the way of good work being done, and this looks like good work. I'm in favor of moving forward. Quite frankly, if unless we have more discussion, I mean, I'm happy to make a motion.
Well, I appreciate that. I think that's really the value of what we do well, and why it's so great to have three commissioners that are so focused on public service and that discussion. I don't like doing math on the fly. I was told there'd be no math, right, as an elected official. But, you know, I would welcome and entertain some dialogue with the applicant if there's any movement on that number. I'm still a no. It sounds like Commissioner Teal is a yes. Kevin's open to potentially some further discussion. So, you know, in my experience, both here and on the Planning Commission, it's sometimes helpful to have additional input from the applicant.
Yeah, I mean, can we request maybe a minute recess just to?
Absolutely. So that might be a good time for a bio break. Let's do a 3-minute recess. We'll reconvene in a few minutes here. So we're going to go ahead and reconvene our public hearing. Thanks to everybody for your patience with that recess. I want to turn it over to the applicant, who hopefully has had some time to have some discussions. Yeah.
Yeah, appreciate the time.
Sure.
So we're doing some more math on our paper over here. And I think what we'd like to propose as a revised calculation here is taking the 9.8 million, I'm going to talk kind of rounder numbers instead of all the individual dollars, taking that 9.8 million, crediting about the 4.9 million as you discussed for the 50%, looking at our 1.375 number, reevaluating that based on the sort of, I know we've talked about precedent a lot here, but other projects in the county, including more of our clubhouse in kind of a more consistent manner, brings that number just over 2 million. And then in light of the 135,000 credit from the previous paid fees, it puts us at what we'd be proposing as $2.7 million for that fee.
Okay. Well, I have to say, first and foremost, thank you. I think that really is helpful. And, you know, I have a lot of respect for the business community, and that is not our lane, no pun intended. We expect you guys to bring that information forward, not us, and we defer to that. So I really appreciate the concession there, and I think I would be supportive. Additional comments from our board?
Very much appreciate the developer doing that work on the fly really quick. Hey, thank you, Doug. I do appreciate the developer doing that work, really flying on the quick. Once again, it does seem reasonable to me. When we're ready for a motion, I'm prepared to offer one.
Thank you, Commissioner. I'd love to hear from our third commissioner.
No, and I appreciate that as well. I think in my mind, the basis of the decision that was made by 3 county commissioners, none of which were us. This was a long time ago, and they were deciding what parks amenities should be proposed for a church property versus an apartment property. I think I've, for one, feel much more comfortable with what's being proposed here, and truly think the thoughtful consideration. To me, the numbers that you went through makes just a lot more sense. And at the same time, the $31,000 per unit is also does not make sense. So that's for me not a starting point. But this to me does make a lot more sense. So I do appreciate that.
Well, thank you, commissioners. I don't have any additional comments and certainly would entertain a motion.
Oh, if you'd like, Mr. Chair, I move to approve Castleview Filing 1, Second Amendment, Lots 1A and 2A, used by special review because it does meet all of the approval criteria with 9 conditions presented. Project File US 2024-009. Does that need any further clarification, Mr. Chair?
Well, I appreciate that motion, Commissioner Van Winkle. I would just ask for a friendly amendment that your motion include the concession made by the applicant.
Certainly, yes.
Okay. Is there a second for that motion?
Yeah, after great discussion, I'll second.
Okay. So we've got a first and second on the floor. Any further discussion? Seeing none, all those in favor signal by saying aye.
Aye.
Aye, and that passes unanimously. Congratulations and our thanks to the applicant. The next land use meeting, public hearing, will be held on Tuesday, June 10th, 2025 at 2:30 p.m. We are adjourned.